I'm Sarah Phillips with Phillips Law, located right here in the beautiful city of New Orleans, Louisiana, where we primarily practice criminal law and personal injury. And this is Law in the Bayou, where we make the law simple and easy to understand. Today I want to talk about grand jury indictments, what they are, how they work, and what you need to know if you or a loved one is facing a grand jury indictment in Louisiana. So the first question I want to talk about is, what is a grand jury indictment? A grand jury indictment is a formal accusation issued by a grand jury stating that there's enough evidence to charge someone with a serious crime. It's different from a regular charge, which is brought by a district attorney because a grand jury is a group of citizens. That group of citizens reviews the evidence and decides whether to move forward with formal charges. So for example, if you're accused of a serious felony like murder, drug trafficking, or embezzlement, the district attorney may convene a grand jury, a group of citizens, to determine if there is enough evidence to indict you. If the grand jury agrees, they'll issue an indictment and the criminal case will proceed. So, how does the grand jury process work though, right? Like this group of citizens. The grand jury process is different from a regular trial. So here is how it works. Number one, selection of the grand jury. In Louisiana, a grand jury is made up of 12 citizens selected similarly to how jurors are chosen for a trial. The grand jury meets in secret to review evidence that is presented by the prosecution. It's important to note that the prosecution presents evidence. During grand jury proceedings only, the prosecutor presents the evidence. The defense doesn't get to participate, and there's no judge present. The prosecutor might call witnesses, they'll present documents, or show other forms of evidence to persuade the jury, the grand jury, that there's enough to justify an indictment. Next is the grand jury decision. After reviewing all the evidence the prosecution has brought forth, the grand jury must decide whether there's probable cause to believe a crime has been committed and that the accused is responsible. If at least 9 members of the grand jury agree, they issue an indictment, which is also called a true bill. If they don't find enough evidence, they can issue a no bill, meaning no charges will be filed. So an example of this would be, imagine the prosecution presents evidence of a large-scale drug trafficking operation involving multiple people. The grand jury convenes, they listen to what the prosecutor says, they review evidence like phone records, witness testimonies, and financial documents. If the grand jury finds enough evidence to support the charges, they'll return a true bill and the case will move forward. And a lot of times people ask, when is a grand jury indictment required? In Louisiana, grand jury indictments are generally required for serious felony charges, especially those punishable by death or life imprisonment, like murder or aggravated rape. For less serious crimes, the district attorney can file charges directly without going through the grand jury process. So some kind of examples of this would be, if you're facing a charge of aggravated assault, the DA could file charges directly without a grand jury. However, for charges like first-degree murder or capital offenses, the law requires the case to go before a grand jury to file that true bill. What happens after a grand jury indictment? So once a grand jury convenes and they have indicted the person, the case moves into the next phase of the legal process. At this point, the accused will be formally charged with the crime and they will be arraigned in court. The case will then proceed to the pretrial hearings and, if necessary, a trial, right? Basically, it just goes through the system. So if you're indicted for a felony, you will be arraigned. This is when you will formally hear the charges against you and you will enter a plea of guilty, not guilty, or no contest. From there, your defense attorney can begin negotiating with the prosecution, reviewing the evidence, or potentially preparing for trial if they believe that that's in your best interest. A lot of people want to know, can you defend yourself during a grand jury proceeding? One of the most important things to know is that you cannot defend yourself during a grand jury proceeding. As defense attorneys, we don't even know this is going on. The grand jury only hears the prosecution side of the story. As a result, grand juries often indict because they're only presented with evidence that supports the prosecution's case, right? It's kind of well known that grand juries indict on a lot of situations. So for example, even if you have a strong defense for your case, you won't have a chance to present it during a grand jury process. That's why it's crucial to have an experienced attorney ready to step in once an indictment is handed down to begin building your defense right away and protecting you through the court system and your court case, the life of your court case. So what can we as defense attorneys do after a grand jury indictment? Well, after this grand jury indictment, as your defense attorney, we play a critical role in protecting your rights. Right away, we make sure to plead you not guilty at arraignment. We're going to begin investigating the case, challenge the prosecution's evidence. We're going to file those motions to suppress evidence and make sure that everything was good and that that no evidence needs to be suppressed. And also, we're going to try to reduce the charges. For example, if you're indicted for drug trafficking, we might challenge the legality of the search and seizure that led to the evidence being gathered. If the evidence was found to be obtained illegally, we would be arguing to suppress that, which would weaken the prosecution's case against you. A lot of people want to know, can a grand jury indictment be challenged? While the grand jury process is generally secretive and heavily favors the prosecution, it is possible to challenge an indictment in certain situations. For example, if there were significant issues with how the grand jury was handled, or if there was insufficient evidence presented, your attorney could file a motion to dismiss the indictment. So let's say, for instance, the prosecution relied on an unreliable or falsified evidence, somebody to secure an indictment. Your attorney can investigate the issue and argue for the case to be thrown out based on that misconduct or lack of valid evidence. So hopefully this kind of unveils the secrecy of grand jury proceedings and indictments and how they kind of work. If you're facing a grand jury indictment, it's essential to have an experienced attorney on your side. The grand jury process is one-sided, and the consequences of an indictment can be severe. At Phillips Law, we have the knowledge, we have the experience, and we know how to defend you after an indictment is issued to ensure your rights are protected every single step of the way. So I'm going to link a blog below with a little bit more information on grand jury indictments for what you need to know. Also, if you have some more questions about the criminal court process, feel free to go over to our frequently asked questions page on our criminal page. I'll link that below. Give us a call at 504-434-7000 so we can answer your questions and help you out and talk about your case specifically and see if there's anything we can do. And if this video was helpful, please like and subscribe, and let us know if you have any questions, and have a great day.